years old, I sorry, just pop up there. When I was 4 years old, I had to dress up for my end of year Hanukkah concert at school as someone in the neighborhood. And when our names were called, we had to take center stage and announce in song who we were. I actually came dressed up as a liquidator. I wore dark blue jeans, black shoes, a white shirt, and blue tie. Little did I know that 20 years later, I really was a liquidator in the neighborhood. Yeah, the insolvency and business rescue profession is really interesting, and it's obviously a very hot topic at the moment, given COVID and the devastation it's caused in our economy. It's interesting, and what I love about it is that really no two matters are the same. It challenges me every single day, and I think besides my father having practiced as a liquidator and still does for the past 43 years, and his exceptional knowledge and passion rubbing off on me, I think there's just something innate in me about something innate in me to really help people and really try and maximize as much as I can for creditors and help those, especially those that are late to this industry and this act, the Companies and Insolvency Act, which most people are. I'm just going to kick off. I've got just a short presentation. Lisa, just wanted to confirm you can see that. Let me just share my screen. Okay. So yeah, liquidation and business rescue. What's it all about? So just some of the key terms and really just lay the foundation for the talk. Really, what does it mean for a company to be insolvent? There's two terms used, factual and commercial insolvency. So factual insolvency is when a company's liabilities exceed its assets. So on a balance sheet for accountants, as they know, is you owe people more money than what you have and able to pay. But specifically your assets, your liabilities exceed your assets. I'll give you an example. Down the road, it might be that you've got a property worth 5 million rand, but you owe the bank 10 million rand, and you've got only 100,000 rand in your bank account, and therefore your liabilities in your company exceed your assets. Commercial insolvency, however, is when the company is unable to pay its debts when they become due and payable. So it might be that you are solvent on your balance sheet. In other words, let's say your building is worth 10 million rand and you only owe the bank 5 million rand, but you've got no money in the bank account, and you might have suppliers who need to be paid on a monthly basis. For example, the stationer, the company that leases your printing equipment to you, and your monthly overheads might be 100 or 200,000 rand, but you don't have sufficient cash flow. And obviously you can't then go and sell property immediately to realize some money and pay them. So by not paying your debt when they become due, you commit an act of insolvency. A debtor is simply a term that describes someone who owes the company money. A creditor is someone whom the company owes money to. A winding up is really just another name for liquidation. And financially distressed is a term that's applicable predominantly in this talk to business rescue. And how that differs from commercial insolvency is that it's reasonably unlikely that a company will be able to pay all of its debts as they fall due and payable within the immediate ensuing 6 months, or reasonably likely that the company will become insolvent within the immediately ensuing 6 months. So really, that just means that you might be able to service your debts and pay your creditors on a monthly basis, but you envisage that within 6 months, you're not going to be able to, and you're going to simply run out of money, or your liabilities are going to exceed your assets. So just to go through, when a company is financially distressed, there are two options available. There are actually three, but today we're only going to deal with two. The first option is liquidation. And that is really a process in which a company's assets are wound down, the assets are sold, and monies are distributed to creditors. The test for placing company liquidation, in short, is that it cannot pay its debts as they fall due, and the company is insolvent. There are measures where a solvent company can also apply for liquidation. We're not going to be dealing with that today, but really it can happen when, for example, shareholders are locked in disputes, and a liquidator might need to come in and be that person to come and dissolve or to sell the assets and distribute money to creditors. But for the purposes of today, we're just dealing with insolvent companies. Business rescue. A business rescue is something different in our law. It's a temporary supervision of a company and the management of its affairs by a business rescue practitioner. So unlike a liquidation where you're liquidating the assets of the company and you're bringing the company's operations to an end, a business rescue is a temporary supervision of a company that allows the company breathing space so that a business rescue plan can be adopted and it can put the company back on the streets. The test for placing a company in business rescue is whether or not the company is financially distressed, meaning that whether or not the company in the next 6 months is going to become distressed and unable to pay its debts as they fall due. So what is the liquidation life cycle? This is really just taking you through the procedure of a life cycle of a liquidation. So when a company is distressed, as mentioned, it will either make an application to court. The application will be made either by the company itself, i.e. the board of directors, or it might be brought by a creditor who is owed money. So an application will either be brought to court or a resolution will be filed with SIPC for a voluntary winding up. A resolution will be filed by the board of directors on behalf of the company in most cases. Once an application to court or resolution is filed with SIPC, a liquidation order is granted. And there is something called a provisional liquidation order and a final liquidation order. But for our purposes today, we're going to assume that the company is in final liquidation and is a final liquidation order. What then happens is a liquidator needs to be appointed. So the liquidation order, especially in court, if it's made in court, the application is made in court, generally is public knowledge, and liquidators like myself will hear about it and will then need to get support of creditors to nominate them as liquidators. The Master of the High Court is in charge of the liquidation process, and the liquidation process is governed by the Insolvency Act, read with the Companies Act for the purposes of companies. So what happens is the liquidator will phone up or chase what they call chase support from different creditors. And I'm going to use an example so you can understand how a liquidator is appointed. So let's say, for example, First National Bank are owed R1 million in respect of an overdraft facility. The liquidator hears about this. Neil Gore, being the liquidator, being someone who wants to become the liquidator of the company, he will phone an F&B and say to F&B, here is a requisition form, or to put it in lay terms, almost a nomination form to nominate me as the liquidator. F&B will complete the form to say they are owed R1 million and they would like Neil Gore to become the liquidator. John Smith is another liquidator down the road. He maybe knows that the Telkom is owed money for outstanding telephone bills, outstanding telephone accounts, and Telkom has got a claim for 10,000 Rand. He has got a nomination form in respect thereof. There's a cutoff date by when the liquidators have to send their voting forms, their requisitions into the master's office. The master will then look, once the cutoff date has come and gone, which is a matter of days, the master will have a look and determine two things. One is which liquidator has got the most support in value and which liquidator has most support in number. So in this instance, it will look and say, Neil Gore has got more in value. He's supported by creditors whose value of their claim is higher than anyone else, and it will then appoint Neil Gore as the liquidator, and John Smith does not become appointed. However, if John Smith perhaps had maybe got 10 staff members who are owed money, and the claims total up to even 2,000 Rand, the master will look and say, John Smith has got more creditors in number. He's got number of people, more people voting in favor. And in that case, Neil will be voted in on value and John Smith will be voted in on number, and therefore they'll be voted in jointly. So there'll be two liquidators in the matter. it can happen that Neil Gore or John Smith can have value and number, where the value of their claims as well as the number of creditors they have support from are higher than anyone else. And in that case, one liquidator can be appointed based on value and number. Moving along, once the liquidator is appointed, there are meetings of creditors that are convened. There are essentially two meetings of creditors that are convened in the ordinary course. The first meeting is convened by the master, and the second meeting is convened by the liquidator. The purpose of the meeting, specifically the first meeting, is to have claims proved at that meeting. And what happens is, during the initial period, the liquidator will send out a circular to creditors just to advise of the liquidation, and more often than not attach a set of claim forms. So creditors have to complete a claim form, and the claim form, what is on the claim form is really just setting out what the creditor needs to document in terms of what monies they are owed and in respect of what. So whether it's a loan account or it's for a bond, whether it's for goods supplied, and they'll then have to attach supporting documentation substantiating their claim. So they'll attach an invoice or statement of accounts. They'll complete an affidavit, and they will then send that to the liquidator, who will submit it for proof at the meeting of creditors. At the meeting of creditors, the master will then consider the claims, have a look at them, and see if on the face of them they are fine and they are in order. The master might, he'll prove the claim, but he might reject the claim. It might be because the affidavit is not properly completed, the figures on the claim does not correspond to the invoice. So that would be why a claim might be rejected, and then the creditor would have to go and redo the form and have it submitted at a further meeting of creditors. At the meeting of creditors, a final liquidator is also appointed, but as I mentioned, that's something which we don't have to go into today. Then what happens is, once the first meeting is done and dusted, the liquidator will then have to submit a second meeting report. He will convene a second meeting, and he will prepare a report for creditors. And in that report, known as a second meeting report, he will outline the basics of what's happened in the business, what he has found in his investigations, what assets and liabilities the company has, and what the likelihood is of creditors being paid, if anything. And so he will set that out in his initial report. Furthermore, he'll attach to the back of that report resolutions. And just to take one step back, at this stage, the liquidator has very limited powers as to what he can do. We'll go into those powers shortly. So until he has had resolutions passed at a meeting of creditors, or directions or resolutions passed, he's very limited as to what he can do. So he will submit resolutions to the second meeting, and he will ask the creditors to vote on those resolutions, whereby the creditors give permission or direction to the liquidator as to what he can and cannot do. They are generally a standardized document, and those resolutions will contain things like giving a direction to liquidators to sell assets, the manner in which they can sell assets, whether he can employ attorneys to help him, to be able to compromise or to consider claims. There are certain things that can happen in that report, but that's generally what can happen, and the resolutions are then adopted and passed at the meeting. So once they're adopted and passed, the liquidator can then go and realize the assets of the company, sell assets, whether it's vehicles, whether it's property. He might want to conduct certain investigations or write certain letters of demand via his attorneys to debtors, and deal with contracts and various other things. Once the assets are then sold and he's dealt with these matters, he will then draw what's known as a liquidation and a distribution account. This will really summarize what the assets have been sold for, what the liabilities are in the company, and who is going to get paid. So he will then draw the account. He will show which creditors are entitled to receive money and how much they're going to be receiving. The liquidation distribution account then gets lodged with the master, and it lies for inspection. So what that means is that there is a 2-week period in which any creditor can object to the account. So a creditor might object for any number of reasons. But let's say, for the purposes now, there are no objections. The account is then confirmed by the master, and the liquidator can then go and distribute money to creditors in terms of that account. Once that is done, the distributions are made, the liquidator will then report to the master to say there's no further business, the monies have all been distributed to creditors, and he would like the master then to end the liquidation and issue the liquidator with a filing slip and almost a certificate to say that the liquidation process has come to an end. So I think I've taken you through the process, and we can now just have a look at some questions which I think are very interesting and pertinent, and I think everyone would love to know. What are the duties of a liquidator? Well, as I mentioned, besides for realizing assets, as I mentioned, the liquidators have got limited powers before a second meeting of creditors and before they receive direction from creditors. So what his duties are immediately, as soon as he is appointed, is he needs to safeguard the assets. He needs to find out where these assets are sitting. He needs to take out insurance for the assets to the extent he has funds available. And he also needs to open up a bank account. So the company will have a bank account at the date of liquidation. The bank account will have been frozen by the bank as soon as they hear about the liquidation order, so that any money in the bank account cannot leave the bank account. The liquidator has got, the company now vests with the liquidator. So the directors of the company are no longer in charge and in control of the company. So they are not able to do anything regarding the operations of the company. The liquidator takes over. He opens up a separate bank account in the name of the liquidator, and then any monies that are sitting in the bank account of the company will get transferred to the liquidation bank account. So it's possible that at the date of liquidation, there might be 10,000 Rand sitting in the company's bank account or money market account. The liquidator will write to the bank and ask that money to be transferred. So the liquidation account is then open. He's insured assets. He might take other steps. He might need to put security in place to look after assets. You might have earth moving equipment sitting at a site or sitting at premises, and those assets need to be safeguarded, and the liquidator will take any measures he can to safeguard those assets. So those are just some of the duties of a liquidator. Then I think something which people like to know is, how is a liquidator remunerated? We, of course, we can't do this for free, but the way a liquidator is remunerated is clearly set out in a schedule to the Insolvency Act. It's a tariff that the liquidator is paid on, and it's a schedule next to the Insolvency Act. And what it says is the liquidator is entitled to certain set percentages, and it's on the gross realizations of assets. So a liquidator is entitled to 3% on the sale of immovable property. So such as a building, a flat, an apartment, might be in the company's name, or a factory. So if, for example, all the offices of the company sells for R1 million, the liquidator is entitled to 3% fee on the sale. So he's entitled to 30,000 Rand on the sale of R1 million property, plus VAT if the liquidator is VAT registered. On sale of movable assets such as vehicles, equipment, machinery, computers, laptops, the liquidator would be entitled to 10% on the sale of those assets, plus VAT if applicable. Another asset of the company might be debtors. So let's say there's a company, let's say you're a construction company and you've got clients you've built houses for, and they haven't paid you the balance of the contract, and there might be money owing. So let's say there's 100,000 Rand owing in terms of a completed building property which they haven't paid for. The liquidator will recover that debt and will be entitled to take a 10% fee on any debt recovery. Finally, I think just one of the other common ones is cash found in the estate. So as I mentioned, any money found in bank accounts belonging to the company, the liquidator would be entitled to 1% on cash found in the estate. So if there's 100,000 Rand sitting in the company's bank account at the date of liquidation, the liquidator will be entitled to 1,000 Rand fee on that. Next is extremely important, and really is often the crux of the matter of a liquidation, and how creditors are ranked. I just want to sort of stop at this juncture to say that as soon as a company is liquidated, all monies that are owing to creditors and claims they have are basically frozen. There's a Latin term, I think it's Latin, I hope it is, called a concursus creditorum. And that's really that there's a coming together of creditors. So at the date of liquidation, a creditor has no legal standing to be able to claim money other than in the course of the liquidation and in terms of him proving a claim and him or her obviously being paid in terms of a liquidation account. So a creditor cannot then go and sue the company for money owing. It cannot make demands to pay for the company to pay it. It goes into it becomes a creditor of the company, and it has to wait for its money. And obviously, it's also determined by what ranking it has. So the ranking of creditors, there are generally three types of creditors here. The first kind of creditor is a secured creditor, the second is a preference creditor, and the third is a concurrent creditor. So, sorry, I just want to take a sip of water. So a secured creditor is a creditor that has some form of security over an asset of the company. So an example would be a bank who has a mortgage bond over a property. So let's say the bank has got a registered bond for money over a property. And I'm going to use an example as well now on how they would get paid. So let's say the company has got an office, and the office premises are worth 5 million rand, and that there's a mortgage bond of 3 million rand in favor of First National Bank. So when the property is sold, and let's say it does realize 5 million rand, the bank will be the first to receive money, the proceeds out of that property, and it will receive 3 million rand because the property went for 5 million, so it can receive its full 3 million rand claim. Then the 2 million rand surplus funds will then filter down to the other creditors, known as the preferent and concurrent creditors. If, for example, the office premises only realize 1 million rand and the bank is owed 3 million rand, then the bank will only be entitled to receive 1 million rand. And to the extent that it's owed another 2 million rand shortfall, that will potentially be, that shortfall will rank with the concurrent creditors at the bottom of the food chain, if I call it, for creditors. That's in a nutshell what a secured creditor is and how they have rights over other creditors in terms of secured assets. Next, we deal with preference creditors. So once the assets are sold and all the assets that are not encumbered or not secured by any creditors, they then become known as free residue assets. So in the example I showed you earlier, if the property sold for 5 million rand and the banker only owed 3 million rand, there would be 2 million rand which becomes free residue and available to preference creditors and concurrent creditors. So let's say there's 2 million rand now available. The next creditor in line are employees. So employees are then entitled to be paid in respect of a number of claims. They would normally be owed money for salaries, for retrenchment, which is calculated on 1 week for every year of service. They might have leave pay owing to them. They might have holiday pay owing to him. They will be entitled to be paid next. However, there are limits there are limits as to how much they're entitled to claim as a preference. So in this situation, we'll take one example. An employee is only entitled to claim up to 12,000 rand as a preference claim. So let's say the employee is owed 20,000 rand for unpaid salaries. He will be entitled to be paid 12,000 rand ahead of all other concurrent creditors. However, the shortfall of 8,000 rand, he then becomes a concurrent claim, and that 8,000 rand gets moved to the bottom of the food chain with all the other concurrent creditors. So he will be entitled to 12,000 rand immediately as a first charge. However, the 8,000 rand shortfall he will then move and become ranking with other creditors. So once the employee is subject to limitations, as I mentioned, are paid, and there's still money left over for creditors, the next preference creditor are SARS. So SARS would be owed money possibly in respect of VAT, income tax, excise duties, and various other things, maybe interest and penalties. So SARS will then be entitled to be paid in respect of those different costs, those different claims. There is also a ranking, sort of a sub-ranking in terms of that income tax, but also, not going to dive into that today. So once employees and staff have been dealt with and their preferences claims are paid out or are considered, we then have the rats and mice creditors, the concurrent creditors. And those are people who hold no security or no preference whatsoever. And as I mentioned, those will be people like your telecoms, maybe a Nashua who are owed money in respect of leases for printing equipment. It might be a plumber in a contract. It might be a loan account. Maybe someone has lent the company money and it holds no security. It might even be a mezzanine finance company who doesn't have any security, a short-term loan. So those are how the creditors are ranked and what rights they have. I think something else relevant is really what happens, what is the impact on employees and on their contracts in a liquidation. So at the date of liquidation, let's say you have a manufacturing company, let's say they print, they manufacture t-shirts and you've got 50 staff members. What happens when there's a liquidation? So unfortunately, on liquidation, all employees' contracts are suspended in terms of the Insolvency Act. That means that the employees are not entitled to come to work and perform any work function, and they're also not entitled to be paid. So what happens is, again, they will obviously have to submit claims for any monies owing. And really what ultimately does happen in most cases is within 40, if the liquidator has no reason to keep the employees, they don't need the employees to wrap up the liquidation, whether it's to continue to manufacture, which normally won't happen, and the employees are not required to assist. For example, there might be a debtor's clerk where the liquidators might need to employ. But for these intents and purposes, let's say there's nothing, unfortunately, for the staff to do. After 45 days of the final liquidation order, their contracts will automatically be terminated. So it's first suspended, but eventually it will become terminated. And as I said, they will just have a claim. What they are entitled to do is, as soon as their contracts are suspended on a liquidation, they will be entitled to claim UIF. And if you have a competent liquidator, the liquidator can hopefully get the books and records of the company, which they're entitled to get, and they'll obviously assist employees in completing a UI-19 so that they can go and claim obviously unemployment. Yeah, so that takes care of liquidation, and I will answer any questions that are posted at the end. Let's move along to business rescue. So business rescue proceedings are aimed to facilitate the rehabilitation of a company that is financially distressed by providing for the temporary supervision of a company and the management of its affairs by a business rescue practitioner. And there is, in this case as well, a temporary moratorium or a stay on the rights of claimants or creditors against the company. So as with the liquidation, the business rescue also puts in place a moratorium whereby creditors cannot claim monies against the company whilst the company is in business rescue. A business rescue plan is then developed and implemented to rescue the company by restructuring its business, i.e. property, debts, and other liabilities and equity. Business rescue will generally last, it's supposed to last a period of 3 months. So we will get into that as well, but just to give you an idea of the time frame of business rescue, it's 3 months. So what is the process? Just step by step of what happens. When how is a company placed in business rescue is really either by resolution, again, filed by the board of directors of the company with an affidavit to sub C outlining it's distressed and showing that it's distressed and that it needs to be placed in business rescue, or it can make an application to court to be placed in business rescue. An affected person, we'll deal with what is an affected person, but assuming we know that a creditor is an affected person, a creditor can also place a company in business rescue by application to court. Once the company is placed in business rescue, a business rescue practitioner needs to be appointed. Unlike the liquidation where the master of the High Court appoints a liquidator, the appointment here is actually by the company or a creditor itself. So whoever brings the application of business rescue will put in their documents that they would like to appoint a business rescue practitioner, and they will decide and say who they would like. It's possible that more than one business rescue practitioner can be appointed. It depends. The matter might be highly complex and need extra help. There's various reasons for having more than one practitioner. So once the business rescue practitioner is appointed, he will then convene a meeting of creditors, and also employees will attend, even regardless of whether they are owed money or not. They will generally also attend. At that meeting of creditors, the business rescue practitioner will outline the process and what the current situation is with the company, and also give an idea at the moment whether or not he or she believes that the company is capable of being rescued. Also what happens at this meeting of creditors is the liquidator will ask the creditors if they'd like to form a creditors committee. And the creditors committee is to form whereby the creditors will nominate a creditor representative, someone to act as the head of the creditors committee, that they can then liaise with the business rescue practitioner. It might be tricky for hundreds of creditors to want to deal with the business rescue practitioner on a day-to-day basis, because it's meant to be such a short process that they might want someone to represent them. And also employees might be represented already by, for example, the trade union. So they might have representation as well. Or they might want to also nominate someone to represent the staff members. So the meeting of creditors, they have come and gone. What's next really is for the business rescue practitioner to put in place and circularize a business rescue plan. The business rescue plan, we will also talk about what that contains, but essentially either the plan will be voted in favor or against by creditors. If it's voted in favor, then the business rescue practitioner will implement the plan, and will then, once that plan has been substantially implemented, it will then be the business rescue practitioner will then file a notice of termination of the business rescue to SIP-C, and it will say the business rescue plan has been adopted and it's been implemented, and now the business rescue practitioner will then hand back the company to its directors, and the company will then come out of business rescue. It will be put back on the street, and it can carry on trading, and it's no longer financially distressed. If the business rescue plan fails and it's not adopted, the business rescue practitioner will also have to terminate the proceedings and, in fact, convert the business rescue into a liquidation, and he will take these steps to do so. So I just got four key topics of business rescue I'd like to just dive into. The first is, what is post-commencement finance? I haven't mentioned this before, but as you can appreciate, when a company is financially distressed and it needs money, of course, it's going to be insolvent and have to close its doors within 6 months if it doesn't have any money or its trading activities don't pick up. The company needs post-commencement finance. It needs money from somewhere to be able to pay the costs of running a business rescue. For example, business rescue fees. It might have to pay its expenses to be able to keep suppliers, supplying the company with, for example, materials, or it might need to service certain commitments. It might need to pay the telephone account. It might need to pay security guards that they won't leave site and secure the premises. So without post-commencement finance, the business rescue simply doesn't work. So the business rescue practitioner will have hopefully engaged with the company before business rescue and had some kind of promise or commitment, whether it's from a bank or whether it's from maybe the shareholders, to put money in that are able to run the business rescue procedure and obviously turn the company around. What is an affected persons? So an affected persons is a creditor. It could be an employee, it could be a shareholder, it could be a trade union. There's a whole number of people that are known as affected persons, and they've got various rights and also they might have various voting rights as well when it comes to adopting a plan. So those are what affected persons are, and they have various rights. As mentioned before, but I'm going to just elaborate on it a bit now, is what is the role of a business rescue practitioner? So as I said, the business rescue practitioner's role is really about assessing, is to turn the company around, but it's got to see whether or not the company is capable of being rescued. And the business rescue practitioner has also got to see as well that if the company cannot be rescued, it then has to look at the next scenario, and it needs to decide whether on sale of the assets or sale of parts of the business, whether the result of the business rescue plan and selling assets or doing what's necessary to turn the company around, whether that will result in a better return for creditors than it would on a liquidation scenario. So if it cannot be rescued, then the company might need to be wound down in the business rescue in terms of a plan whereby this plan will result in a better return for creditors on a liquidation, on a business rescue than in a liquidation. So how is a business rescue practitioner remunerated? So a business rescue practitioner is remunerated in terms of an hourly rate, and that's also determined by the size of the company. So there is a provision in the Act for a Companies Act where it will show what the size of the company is and how it's determined. So for example, they might consider the company to be a small company if it does a certain amount of turnover and it has a certain amount of staff members. When it reaches past that point, it goes to the next tier where you might have more than 100 staff and the turnover might be more than 10 million Rand. That will then be considered to be a medium-sized company, and then beyond that is a large company. So if the business rescue and the company is considered a small-sized company, the liquidator is entitled to approximately 1,200 Rand, 250 Rand an hour, including that. For a medium-sized company, I think it's roughly about 1,500 Rand an hour, inclusive of that. And for a large company, the business rescue practitioner will be entitled to approximately 2,100 Rand, inclusive of that per hour. It's possible that the business rescue practitioner looks at it and says, this is a very highly complex matter. It's going to require a lot more expertise, and the business rescue practitioner might want to be paid a slightly higher tariff, especially given its years of service. A senior practitioner, might look at it and say, for 1,200 Rand an hour for a small company, it's a little bit low, and he will then ask creditors to approve a higher tariff, and that needs to be approved by creditors. So he may not go and ask for and just simply pay himself more money without the approval and voting by creditors. I just want to take you back just to talk a little bit more about the business rescue plan. The business rescue plan will, as I said, it will include exactly what the assets and liabilities of the company is and how the liquidator envisages turning around the company and putting it back on the streets. The plan has got to be voted by creditors, and without that vote, it cannot be adopted. The creditors have got to vote. All creditors need to vote. 75% of all creditors present at the meeting have to vote in favor of the plan. And in addition, more than 50% of independent creditors have to also vote in favor of a plan. Independent creditors are creditors that are not associated or connected in any way to the company. So for example, if a shareholder or director has lent money to the company and he's owed money, that claim that he has is not considered to be independent, and he's not an independent creditor. So for example, a bank or SARS would be known as an independent creditor. So the vote to adopt the business rescue plan has to be as follows: 75% of all creditors present at the meeting have to vote in favor of the plan, and more than 50% of independent creditors have to vote in favor of the plan. I think I've spoken enough. I think that really I've tried to summarize as much as I can and highlight the key matters and liquidations of business rescue. And I would like to open it up to the floor now for any questions that listeners might have.
Dean, you got a question?
Yeah, morning, Neil. Hope you're well. Thanks very much. Very informative. I appreciate the time you've given. The question I have for you is kind of a two-pronged question. The first is, when do you know that it's time to consider either the business rescue or the liquidation? And the second part of the question, in general, do you first default to business rescue, or do you say, listen, we're going straight to liquidation?
Excellent questions, Dean. So I think it depends on a number of factors. And as I mentioned as well, is business rescue is first and foremost that you need, as I said, PCF, post-commencement finance. So if the company is simply not able to get post-commencement finance to turn it around, then obviously it's in a way a non-starter, because obviously the business rescue is brought about where it's financially distressed, it hasn't got enough money to carry for the next few months. So without post-commencement finance, you simply it's very difficult to go and start a business rescue. It does happen that, you know, the business rescue application is brought and it's promises, and there are promises made by people that money will become available. But what happens is if the business rescue order is granted and money does not become available, well, then the business rescue practitioner has to terminate the business rescue immediately. It can't continue because it doesn't have any money. Obviously, there's factors to consider whether a company needs to be liquidated or business rescue. But so that's really the answers the business rescue leg of it. And obviously, sorry, Dean, why don't you just remind me what the second leg was of the question?
Just was when you actually know that it's time for either the business rescue or the liquidation.
Well, I think the timing really is obviously how much pressure that the company is under, and obviously if you're not able to, I think the moment you're unable to pay your debts, I think when they fall due is really, I think, the signal. You know, as I mentioned, you might have assets in the company and you might be able to realize property or sell some machinery to get some funds in, but at the end of the day you've got commitments, and you know the financial institutions and maybe mezzanine finance companies are not going to wait around forever waiting for their money. They might give you some breathing space to assist you. So at that point, if you're unable to pay your debts as they become due and you just simply can't keep your head above water, that's the time to really engage with you know, an attorney or potentially a business rescue practitioner, and to get some advice, you know, at what stage now, because there are also risks. I thought I could just mention, there are also risks that if you have limited funds and you can only pay certain creditors and not others, there is dangers that money and that transaction could be attacked by a liquidator down the road, because the Insolvency Act is quite clear that at a time that a company is insolvent, it cannot prefer one creditor over another. So if you've got some money and you say, look, I need to pay my staff tomorrow, they're going to go on strike, I'm in trouble, but you've got 10 guys who are subcontractors are doing building for you and you're not paying them, you know, why should staff members get paid and not the builders? So it's a very delicate situation. You've got to really be careful. And my advice would be, well, just suggestion would be that you need to take advice and you need to take a legal advice on the matter before you know, you take certain steps, because once you're distressed, it's a very, very delicate situation, and there can be a lot of consequences if you make the wrong decisions that are contrary to the Insolvency and Companies Act.
Neil, do you mind if I just come in and just put some legal structure to what you've said?
Sure.
Can you hear me, Lisa? I don't know if you're muted. Can you hear me?
Yes.
All right.
Yes,
so
we can hear you.
I just wanted to make the point, Neil's obviously 100% correct, but looking at the Act itself, if a company is financially distressed, and that's defined in the Act, and it considers that that means that it's going to consider that within 6 months it's going to be insolvent, you've got to make a decision to place the company in business rescue. And if you don't place the company in business rescue, you've got to notify all your creditors what you are going to do, that you are financially distressed and how you're going to work your way out of it. Now, I don't know a single director of any company that's ever put his hand up to say, I'm going to go insolvent within 6 months. I'm trying to work my way through this, because as soon as he does that, or as soon as the board does that, then people will stop supplying that company and it will fold. So generally, although the act is clear, and if you don't do that, the directors could be held personally liable. So you've actually got to, when you decide that you're financially distressed, you've either got to put yourself into business rescue or notify your creditors that you're financially distressed and what you're going to do about it. Once you're placed in business rescue, Dean was asking at what point do you decide it's going to work or not going to work. I think there's obviously pre-business rescue, that's the act takes care of that. But once the business rescue has been granted, either by way of resolution or court order, then if you can't borrow the PCF that Neil's been talking about, the post-commencement finance, if you can't borrow the money from anyone, well, then the company is going to fold and you're going to pull the plug on it because you've got no money. If you get, even if you get the post-commencement finance, you'll go to the creditors meeting and say, we think this company's got a chance of succeeding and we're going to put together a business rescue plan. Then you convene the meeting to consider that plan, and the creditors may vote against the plan for whatever reason, because they don't believe it can work or they feel they'll be better off on a liquidation. And they vote against the plan, and that's the end of the business rescue. So that's just to give some legal structure to what Neil's been saying.
Thank you. Thanks, Stephen. I think Dana's got another question.
Hi, thanks for this. Can you, where is the legislation with regard to post-commencement finance in terms of the security and in terms of its preference? Where is it coming in at the moment? I know, because when I was involved, it was very unclear as to seniority of it.
I actually don't mind referring this one to my dad, but as far as I know, it is in the Companies Act, it's mentioned, but Dad, you can just maybe elaborate on that.
A business rescue practitioner now has to borrow money, otherwise he can't run the business. So he can borrow, he can enter into an agreement with a lender, and he can give that lender security. So if he's got unencumbered assets, you know, if there's a property that's not fully bonded, he can give a second bond or whatever. But if the lender will lend without security, then obviously you can borrow that without security. If there's a subsequent liquidation, then there's an order of preference that comes in. So if the business rescue fails, then on liquidation, there's certain protections, and the first people to get paid, or as always, would be the costs of liquidation, being the liquidator and the actual costs of liquidation. After that comes any amounts owing to the business rescue practitioner, and included in that are like legal fees. It's the business rescue practitioner's own disbursements. So that's next. Then comes the staff for any amounts owing to them during the business rescue. And after that come the post-commencement finance lenders and anybody else who supplied the company with goods and services during business rescue in the order, in the date order in which they supplied the company. It's pretty complicated stuff.
Yeah, no, so what I'm trying to understand is in terms of rulings that have happened in, say, the last 3-4 years, has there been, you know, in other kind of, I can talk to the US in the Chapter 11, the DIP financing, that has the first, that is, you know, before anything else, actually gets paid before practitioners, before employees. So the post-commencement financing currently, where it's sitting, hasn't changed in terms of its seniority. It's still quite, they're lending at more at risk than in, say, other jurisdictions.
There's no question.
And
that's
so
why
therefore
it's so difficult to get post-commencement finance unless you're giving them hard security. Because as soon as you lend the company, and I'll tell you why some of them do succeed and you can borrow the money. So for example, you've got one of the banks that's in for 100 million rand in a huge business rescue. And if the business rescue fails, then there could be blood all over the floor and the bank could really lose out. So the bank may lend you 5 million rand to protect the 100 they're already in for. And on that basis, the bank may not even insist on further security, or may lend the money under the existing security they hold. So but it is a difficult, so for medium-sized business rescues and small business rescues, it's virtually impossible to borrow money.
So that's basically, so the post-commencement finance market hasn't really opened up because of the legislation of where the level of security is in the legislation. Is that correct?
Yes, I believe that there's stronger in other jurisdictions. There's a higher preference given to post-commencement finance than in our jurisdiction. So I think it's a weakness. But please believe me, Chapter 6, the business rescue provisions are a nightmare. That's why there's so many judgments. There must be 200 and something judgments already around business rescue, trying to buck up what the Act's supposed to have done, or how it's supposed to be interpreted. It's a problem. The Act's a big problem at the moment.
Okay, thank you for that.
Thank you. I think there's time maybe just for one last question, which has come through for you, Neil, is what happens if fraud is detected in a liquidation or a business rescue?
Okay, so fraud, let me start with the liquidation. So the liquidator is obviously now he's got control and the company's vested with him. And if he obviously detects that there's fraud in any way, there are various mechanisms. Obviously, he'd want to try and recover based on that fraud. The criminality side of it has got nothing to do with the liquidator. I mean, he can obviously recommend, he's entitled to go and potentially lay charges if he wants to, but generally it's a civil matter that he would look really closely at. In a liquidation, he can do a couple of things, and one which is a really good mechanism we use is he can convene a 417 inquiry, and really what that is it's an inquiry. You've seen various inquiries in South Africa, the Zondo Commission, etc. But what it is it's really a fact-finding inquiry. He convenes it by application to court, and he asks the court to convene, to give permission to convene an inquiry where a commissioner is appointed. It's normally a retired judge or a senior advocate. And the liquidator is then entitled to subpoena witnesses to the inquiry for the purpose of interrogation and fact-finding, to collect information and obviously interrogate witnesses. So, for example, the fraud might be based on the accounting transactions. And what he'll do then is the liquidator will be entitled to take all the information, all the evidence given, and he'll be able to use that in a civil suit. So whether it means he's going to then sue the directors personally or any other people associated or anyone else that's committed fraud on the company. So that's a very strategic, it's a very well used and successful mechanism to be able to recover as a result of fraud. So I think that's just one of the main ones to chat about. Business rescue, obviously there's fraud detected and the company is still really essentially a company just under a temporary supervision. So from what I understand is I think that the normal laws would apply. So for example, if the fraud is detected by a staff member or a director, the employees, the Labor Relations Act would then govern that. Because it's like in any business, if you find that the staff member is stealing, it would have to follow the CCMA and the procedures. So whereas liquidation is specific procedures, business rescue would follow, I think, the ordinary course of the Companies Act and the Labor Relations Act.
Thank you. Thanks so much, Neil. I think unless anyone else has a question, that kind of brings us to the end of this webinar today. Just wanted to thank you so much on behalf of ORT for your time and for just dealing with this complicated issue, which it is for most people, but for putting it across with such clarity and just for just us ordinary people to be able to understand something that's quite important in the business world, unfortunately, especially at the moment. So yeah, just big thanks from us and to everybody else. Just wishing you Shabbat Shalom and a good weekend.
Thanks, Brenna. Thanks, Lisa.
Thanks so much, Neil. Great. Thank you.
Bye.